Thank you for joining us for Professor Veronika Fikfak's inaugural lecture titled Hope in Human Rights and International Law. My name is Professor Benjamin Lauderdale. I'm the head of the Political Science Department here at UCL, and it's my great pleasure to welcome you here for this inaugural lecture. Professor Fikfak will give her lecture shortly after an introduction by Lauge Poulsen, who is Professor of International Relations and Law in our department. Following the lecture, Lisa Van Halle, who is Professor of Political Science in our department and UCL Pro-Vice Provost for the Grand Challenge theme of the climate crisis, and David Feldman, who's Emeritus Rouse Ball Professor of English Law at the University of Cambridge Faculty of Law and Emeritus Fellow of Downing College, Cambridge, will give the appreciation. There will also be a drinks reception after the event, and this will be in the Wilkins Japanese Garden, accessed through the Student Center. Lisette and Ed's there. Not sure where Lisette is, will be able to guide you there. So I'm going to go ahead and hand over to Lauge to give the introduction.
Thank you, Ben. It is my pleasure and my honor to introduce Professor Veronika Fikfak at tonight's inaugural lecture. Veronika is widely regarded as one of the world's leading scholars of human rights and international law. She has published in pretty much all the major journals in the field. She has received major prizes for her scholarship, including one just last year from the American Society of International Law, and she has won major grants from research councils in the UK and abroad. Veronika is also regularly called upon by states and other actors to advise on sensitive human rights and other international law matters. She testifies before parliamentary committees, and she's a judge ad hoc at the European Court of Human Rights. She is, in other words, taking up her professorship here at UCL on the back of a truly impressive and distinguished career. But what is it about Veronika that makes her stand out in the large and rapidly growing area of human rights and international law? Why is she unique? What is it that makes her distinct? And ultimately, I think it comes down to her perspective, to her starting point. Because unlike traditional doctrinal scholars in the field, Veronika's work doesn't take its starting point up on the mountain of international public law, or public international law. Yes, she's an expert on public international law. She's an expert on matters of state responsibility and Vienna Convention and the law of treaties and international dispute settlement, the intricacies of human rights conventions and so forth. But while that might be her background as a doctrinal lawyer, it's not the main focus of her research. Her work is not looking for ever more pristine, abstract doctrine somewhere up in the clouds. Instead, Veronika's work takes us down to the messy realities in the real world. She looks at individuals, their motivations, their behavior, and what individuals mean for international human rights law on the ground. She gives us the perspective of the victim, the migrant, the prison inmate, torture victims, sexual abuse victims. But she also looks at other individuals. She looks at the government official, the lawyer, the individual panelist, a judge on a tribunal, the clerk in a secretariat. The individual is almost always at the center of her work. And so it's not surprising that Veronika and her research teams are today at the very center of the behavioral turn in international law, studying individuals and how they process and respond to information in ways that shape international law and has profound implications for how it's applied on the ground. Secondly, and related, Veronika is an institutionalist. She shows us how human rights and international law is mediated through institutions, often in unexpected ways, that we would never have appreciated if we only read doctrinal scholarship. So let me give you an example. A few years back, Veronika documented how a little-known administrative procedure, which initially looked eminently reasonable, ultimately ended up weakening some of the core objectives of the European Convention of Human Rights. In short, the court initiated a technical process to reduce its exploding caseload, whereby its administrative body, its registry, would identify cases suited for settlement rather than having them go through litigation. And that seemed reasonable. More settlements would allow the court to reduce its caseload, run more effectively, and victims could get compensation relatively quickly. And if we look at some of Veronika's other work, we should also intuitively think that this would be a win for human rights victims in other ways. Because she has shown, for instance, how when cases go to litigation, the court doesn't properly consider the victim in determination of damages. And more broadly, she's documented the various ways in which the court spends considerable effort doing litigation, trying to manage its relationship with states, rather than focusing on the victims. So from that perspective as well, a fast-track settlement process might be a progressive step, not just for the court as an institution, but also for human rights victims in Europe. But, and this is where it gets interesting, that administrative process generated an incentive problem for the system as a whole, because the court and governments on the receiving ends of complaints now had a joint incentive to get victims to settle, to go away. And indeed, Veronika shows how it resulted in a network amongst lawyers and lawyers acting for states on the one hand, and staff working for the registry of the court on the other, effectively working together, informally, but nevertheless working together to serve their own institutional interests, and often at the expense, at least in Veronika's analysis, of the victim, who were pressured to settle for even less than they would have achieved through litigation. And so by documenting these institutional dynamics and how they interact with power, how they interact with incentives, Veronika has helped open a black box of practice in human rights law that we previously didn't even know existed, or at least we didn't have much of a grasp of. And she shows how it has major implications for the protection of human rights, for justice, and how it's deeply inequitable. And so I think that's one example out of many, how while Veronika is trained and widely respected as a legal scholar, a legal practitioner, she works and she thinks as a social scientist. And that's unique. I think it's distinct, at least in Europe. And Veronika is not just focusing on individuals and institutions in her scholarship, she does it in her life as a scholar as well. She has a decidedly social approach to her work. She seeks collaboration. She supports and mentors junior scholars. She builds and she leads teams. And as an institutionalist at heart, she doesn't just study institutions, she also spends considerable time and effort contributing to them and building them. She has leadership positions in both the European and American societies of international law. And from the moment she began at UCL, she began investing time and effort in our institution as well, and our department. And so by putting people and institutions at the center of her work, she has not just established herself as a distinct scholar of human rights and international law, but also a wonderful colleague and friend here at UCL. So congratulations with the appointment, Veronika. Over to you.
Thank you, everyone, for coming. I think I've got a challenge today. First is to follow Lauge. Thank you so much for that. The other one is, I chose this topic in 2024, the title of the talk, when things were a bit different. But Mission Impossible is in the cinemas, and I am ready to take the challenge. So when you ask international lawyers to describe the last 5 years, what we would say is that we are in a state of perma-crisis. You've got the invasion of Ukraine, the starvation in Gaza and Sudan, lack of action on climate change. These are just some of the headlines. But then if you prod a little deeper, an international lawyer would tell you, well, look at a few cases. The International Court of Justice issues a provisional measure against Israel that it needs to provide humanitarian assistance into Gaza. Israel does not comply. The European Court of Human Rights orders Russia to release Alexei Navalny. Alexei Navalny is poisoned and killed. The European Court issues a judgment against Switzerland to reassess and address its climate change goals. Switzerland insists it's doing enough. And when you look at it even further, what you see is that actually states are taking a step longer, a step wider. And what they're doing is, at the moment, for example, United Nations is really struggling to get through its meetings, to meet, and to hold states to account, because countries are no longer paying into the court, into the institution's budget. So if you read the news, it seems that states have gone rogue, that they're not complying with international law, and that ultimately international law doesn't matter anymore. And when I was preparing for this lecture, I wanted to know, is this new? Is this something new? And I looked back to 1980s, and I found a symposium published on the topic of hope and human rights. And at that time, what that symposium talked about was about the gap between the reality of what we're living and the aspiration of what human rights and international law ask us to seek. And it was about this gap that symposium talked about, a gap between what the law says and what is happening on the ground. And the organizers, this was Cold War, right? The organizers asked, is there anything to be hopeful about? And at the time, the first ICJ judge, the first female ICJ judge, Rosalind Higgins, wrote that although reality requires us to acknowledge that there are appalling human rights violations happening around the world, it does not require us to assert that there is no international law of human rights at all. And so what she's doing in that paper is she's essentially rejecting this idea that because of the compliance gap, because of this gap between what the reality is and what the law says, that we should come to the conclusion that there is no law at all. Because she sees in the existence of international law, in the existence of rules, she sees hope. And what we are talking about is really the question about how, right? So how do we bridge the gap between what the law says and getting it implemented into reality? But Judge Higgins isn't the only one to talk about that the mere existence of international law, of having rules, gives us hope. You've got Mary Robinson, the UN Human Rights Commissioner, who says that any document of international law is a document of hope. It is a document that we will one day prove equal, that we will face the political and cultural challenges, that we will realize human rights, that we will bridge the gap between history and aspiration. Now, these two women, these two lawyers, underline the importance of having law. And we need to have law so that we're able to put a label on what is happening, that we're able to say, this is a breach, this is a human rights violation, this is an atrocity. But political scientists have gone further than just saying law is important. What they've done is they've actually measured and looked and analyzed how having law makes a difference to people's lives. And so Catherine Zucchinik, a human rights scholar at Harvard, in her book Evidence for Hope, talks about how having rules has improved our lives, how having human rights over time has improved our living conditions, the status of women in society. It has increased equality. And so what she does in her work is she shows that over time, genocide has actually declined, as has violence against civilians. And healthcare has increased dramatically, as has education. And although she admits that change comes slowly and through struggle, we can't deny that human rights movements have been vastly effective. And so what I'd like to do today in this talk is really I'd like to join these colleagues, these human rights colleagues, these women who have come before me, and I'd like to explain why I share their hope for the future. So I've spent the last 6 years studying how states react to international institutions, specifically to judgments of the European Court of Human Rights. And although the majority of our publications are going to be about what doesn't work, and I really want to underline the negative bias coming from publishers, peer reviewers, and impossibility of getting anything positive through the process, but what I'd like to do today is focus on the positive, on what works. Now, as a matter of law, right, when an international or human rights court rules against a country and says you have committed a violation, that country has an obligation to comply, to obey, to stop the breach, to release Alexei Navalny, or it needs to pay damages. And ultimately, often it will also have to change the domestic processes and release people or make sure that violations don't happen in the future. In our analysis, and this was a team effort, in our analysis, we find that countries react to these judgments in very different ways. Some are quick to implement, and some take a long time. But what is consistent across the board is that the states know when they get this piece of paper that they will be held to account. They know they will have to defend each choice they make before international courts, in meetings with other states, and so they know they need to be careful about how they respond to these judgments and how they need to make their response look like they're protecting human rights. And what is interesting that even in regimes that challenge human rights, officials do not opt to openly defy on international institutions. Instead, they go for a softer reaction. And as Lauge mentioned my work on settlements before, so what we found is, for example, that in Hungary, when Orban comes into power, what he does is instead of going and litigating cases in front of the European Court of Human Rights, he makes them go away by settling 50 to 60, even 70% of all human rights claims. And by agreeing to this settlement, what happens is that essentially he's making cases go away. He's escaping the condemnation of international courts. He's doing it in a way that is permitted under international law, and victims get compensation, and the state acknowledges violation. But what is interesting is that in some sense, these settlements actually reinforce the force that the judgment has if they hadn't gone to settlement. So the next time around, when a judgment, a negative judgment comes against a state, it can't avoid but comply with it. And actually, we see this with Hungary. When it receives a judgment, when it doesn't settle it, next time around, it doesn't resist compliance, but it seeks to change legislation and undertake other measures. So open defiance of the court is actually very rare. The only example, one of the examples I can provide is, for example, the UK prisoners cases a decade or so ago, when David Cameron publicly in Parliament said that to give prisoners the right to vote made him sick. Even that decision, 10 years, 14 years later, has now been complied with. And like in the UK, also in other countries, defiance is usually only temporary until there's a change in domestic climate or a change in government. And so what this shows is that when a court finds a country in violation of human rights or international law, that is not easy to ignore. It's a piece of paper, a declaration that you need to respond to. So what we find when we analyze 25,000 decisions of the European Court of Human Rights, the full database, against 47 countries of the Council of Europe, we find that 85% of all of those decisions are complied with. Some quickly, some take time, but they are complied with. So when we talk about a crisis of international law, of human rights law, we're really talking about the gap between the law and the reality. We're really talking about the 15%. So one of the main findings of our project, at least as it applies to Europe, is that most states respect most international law most of the time. And so we wanted to understand why this was the case. What is it that is creating this compliance pool that states are actually respecting international law? And there are two things that are working, two elements on different levels. One is on the state level, and the other one is on the system level. And what we find on the state level, that really compliance within a state, within a country, is about people, right? And that people build relationships with other people. And if, right, compliance depends on that official in a specific place, that official often cares about how other people perceive them. They care what reputation they have, and they try to be accommodating. And so what we've done in our project, that Nicolo is here, who built these social networks, we've actually tried to reconstruct the networks of individuals within a country that are responsible for ensuring that judgments are complied with. And some of these networks are centralized, so there's one actor, and some are dispersed or decentralized. But what's really interesting is that even in the countries that are centralized and where an autocratic leader comes in and captures that network, effectively what happened in Hungary is that there was one person that was responsible for complying with all of the judgments, and Orban comes in, adopts legislation, disables this person for performing their work, taking away their powers, and so our network effectively becomes unfunctionable. Even in that case, what we see is other actors in our social network light up and take that place. And those are the NGOs in the case of Hungary. In the case of Poland, where the network isn't so centralized, when you've got multiple actors who are responsible for compliance, once one of them is disabled, the other ones come in. And so we see a lot of activity from these individual actors coming in, mobilizing to make sure to be accountable and to make sure that international law is respected. The second element is at the level of the system, right? And so what we look is really whether the behavior of one single state affects the whole of the European human rights system. So we reconstruct, we model, we simulate 47 countries and how they're connected. And we know that these countries talk to each other, that they meet each other, that they share practices, that they learn from each other, that they imitate each other. And we want to understand how the behavior of one of these countries spreads around the network, spreads around the model. And so what we find is really that this domestic behavior often spills over and impacts what happens at the international level, and that it does so like a virus. And that is true both of positive and negative behavior. So for example, what we see with Hungary is when Hungary starts settling all of the cases, we notice it in the other countries, and we notice other countries wanting to get away from judgments. But overall, we are seeing that negative contagion is limited, and that instead, overall, over the 46 countries, the positive complaint behavior is the one that spreads. And we want to understand why. And when you look at it closely, and when we had our case studies, what we find is that really there are certain states within Europe that insist on being human rights champions, that call themselves partners of international institutions, or that label themselves, just a few days ago, guardians of a rules-based legal order. And what these states do is they essentially want to act as example to other states, and they want to encourage states through their example and through the spread of good practices to improve. And so they build first on the quality of the relationships that they build with these states, right, on an individual level and then on a group level. Secondly, they mentor these states, and they mentor especially states that don't have capacity but want to do better, that don't have the know-how but want to do better, and don't know how to utilize their resources. And finally, these countries, these champions of human rights, are the ones that believe that we, over time, cannot lower human rights protection, but actually that human rights protection needs to be leveled up. And so officials that we've spoken, human rights monitors, NGOs, are pushing for the protection to expand and to be better as we move forward to new areas. And so the system, the way it works currently, actually fosters this compliance pool. One country mentors another country, and those countries create a sort of collaboration that then spreads across the whole network. And there are many countries that are such champions. I want to mention the UK as one of them, even though we've had examples of delayed compliance. I want to mention Denmark, even if at times it plays tough on compliance, and I want to mention Slovenia. When you look at several decades of practice of human rights, what we see is that these countries are guardians of the rules-based legal order, that they're champions of human rights. So it is these research findings really that give me hope when I look more broadly at international law. And I really want to underline 3 reasons why this is the case. The first one is the one that Rosalind Higgins and Mary Robinson pointed out, and that is that international law per se gives us hope. It gives us a vocabulary with which we can label what is happening in the world. We're able to label things as genocide, as crimes against humanity, as war crimes, as torture or starvation. This is the language that tells us what is the specific evidence we need to prove that these acts have happened. And I want to say that, during the last 2 or 3 years, coming into my human rights world politics class, I have never met students who are so well informed as today in terms of thinking what evidence you need to show motive and to show intent to commit genocide. But the value of international law is also in fostering a particular kind of argumentative practice, right? International law requires of public authorities, it requires of governments that they justify their decision publicly against specific types of values and interests, and that they subject their decisions to external scrutiny. That's why we're hearing everything on the news. That's why we hear people criticizing what is happening. And Philippe Sands' most recent book, 36 Laundry Street, talks about impunity. It talks about Pinochet and Walter Ralph getting away and not being held to account. But even putting a name of what happened in those cases, even saying genocide or crimes against humanity, even just an issuing of an arrest warrant, that is a way of holding to account, a way of naming what has happened. So that's my first point. My second one is I see hope in human rights and international law because of the people who work in this area, both officials in international institutions and in governments, and activists in NGOs. So in our research, we've interviewed a lot of people in a lot of countries and in a lot of institutions. And what we've actually found is that a lot of these people are actually working very hard as they can within the confines of their positions to get human rights implemented, enforced. And actually, a lot of them have been very open to implement changes when we suggested them to very flawed processes. So when the European Court of Human Rights, for example, when we found that they were lowering damage amounts depending on how many victims there were in a case, and that this didn't provide an incentive, or that it actually disincentivized states from stopping violations, the court adapted its calculations. The department who monitors compliance in Strasbourg, when we showed them that you need to pair countries who are going to be a positive influence, that you need to pair them together so that they ensure that it is the good practices that are learned, they wanted to know how they could do that better. Now, I want to be clear. I know that we are now seeing a pullback from international law from countries that used to be leaders in this area, and that's the US. But I think this is the case on the question of the war in Ukraine. Europe, UK, but also other countries can step in and lead the effort and be the positive example for other states. And finally, in the last 5 years, I've witnessed incredible mobilization of people, a sort of a movement of international law. And specifically, I've been impressed by young people across countries using international and human rights law to argue for a better future. And they have built creative arguments using constitutional law, human rights, asking courts to tell them exactly what the obligations of states are under domestic and international law. And what is interesting is that this trend of activist litigation that we had in front of international courts, it isn't limited only to youth movements. In fact, now we're seeing the contagion effect has moved to states. And anyone who has watched, right, we're seeing states mobilize and rush to The Hague so that they can also intervene in cases like South Africa versus Israel, or in the climate changes in front of the International Tribunal of the Law of the Sea, the Inter-American Court, the ICJ. Most countries want to be seen, and most countries want to intervene, and they want to spell out both what they think the obligations are, but also they want to call for respect and enforcement of rules of the international community. This is a new phenomenon. We didn't see this before. And in this age of Instagram, appearing in The Hague, having your moment in court, showing that you stand on the right side of history is important, not only to individuals, but to states. And so I've got many colleagues in the room today who appear for states or for individuals in front of international courts and make arguments using, asserting, relying international law. Many more of us are working and thinking on how to give the decisions that come out of these courts, how to give them bite, how to ensure that they're enforced and respected. And we too are using creative arguments of how international law could be enforced. We're thinking how to reinvent the system. And one thing is, for example, to improve access to more victims to international courts. That's my next DRC project. And then to provide, for example, reparations and for reconstruction of Ukraine by confiscating assets and things like that. So if today you ask an international lawyer how they're doing, they're going to tell you that they've never been busier. But in one way or another, all of us are involved in this kind of mobilization, in this movement. And we're looking at how we can make international and human rights law work better and make the world better. And so for me, it's really the law, the people, and this mobilization, the movement, that gives me hope for the future. But I wanted to end on a personal note. I wanted to talk today about hope, really because of where I come from and because of the people I've met and people that have accompanied me on my journey. I've been really lucky to have many wonderful, terrific mentors, bosses, colleagues here at SPP, Lauge, Lisa, Ben. In Europe, my thanks go to Michael and Anne and Glider. And in Oxford, my supervisors, Dan, Vaughan, and Chris. And in Cambridge, to Jeff and to David, with whom I've shared a classroom for 7 years, and we discussed, we tried to figure out how states are born, how they develop, and how they die. I've been super lucky to work with wonderful, wonderful teams of early career scholars. Nicolo and Laura are here today, but there's also Donata and others. These early career scholars have made what is usually a very lonely life, academic life. They've made it worth pursuing. And I feel that as they go on their path, academic path, they're step by step making the world a better place. My parents-in-law are here today, as is my husband. My husband has been by my side for almost 20 years. He's the one who listens to every plan I've got and every potential project, and also things that don't become projects. And he's the one who sits with me when Excel crashes and when the equations I get or the results I get are wrong. But the people I want to thank most are my parents. My dad, who's a cultural anthropologist, has taught me everything about being an academic. And my mom, who's an epidemiologist and believes that we have to make a difference in life and encourages me always to do better. Now, I was raised in Slovenia in the 1980s. At the time, Slovenia was a socialist country. And every morning when we came to school, we pledged allegiance to Tito, a benevolent dictator who by then had been dead for 6 years. If we wanted uncensored news or American movies, we had to steal the signal from the TV from Italy. If we wanted coffee or chocolate for Christmas, we had to drive to Italy and then smuggle it in the seats of our cars. Today, of course, Slovenia is independent. It's a democratic country. Times are different. It is one of the best examples in our data set of compliance with human rights. But in the 1980s, at the time when Rosalind Higgins was lecturing about hope and international law and hope that international law can give us, my parents raised me to be open to the world, to love knowledge and to be critical, and to never, ever accept status quo as a given. I think for many of us coming from Eastern Europe at the time, international law and international institutions represented a promised land. And so looking back today, 40 years later, it seems perhaps inevitable that I would become an international human rights lawyer and academic, working to make human rights a reality for victims of violations. I think it's in large part because of the people who helped me get here. My parents, my mentors, my colleagues, the people who had belief and faith in me and hope. So I want to thank them, and I want to thank you for your attention. Thank you.
Hello, I'm David Feldman, and it's a great honour for me to be asked to appreciate both Veronika and her lecture. She and I were colleagues in Cambridge, and colleague is at best an ambiguous word, because as some of you know, there are at least 3 different kinds of colleagues. There are the ones, if you come up with an idea for doing something really worthwhile, think of many reasons for not doing it. Then there are the ones who are happy to accept that there are good reasons for doing it, as long as you do it and not them. And then there are the ones who, if convinced it's a good idea to do it, immediately say, how can we do it well together and make it as good as possible? Veronika falls into the last category. It was a great joy to be her colleague in Cambridge, and as she mentioned earlier, one of the fruits of our cooperation was a rather strange master's course, which I think we certainly enjoyed. There's at least one of our students here this evening who says that she still remembers it fondly. But the combination of Veronika's enthusiasm with her rigour and her ability to encourage people, me included, to come up with ideas and arguments and knowledge that we never knew we had, and to weave it into some sort of coherent thought pattern is remarkable. And I have benefited hugely, both when we were teaching together and working together more generally, and since Veronika left Cambridge to move onward and upward. I'm extremely grateful to you for all that you've done to open my eyes to different aspects of the interface between international and national institutions, officers, rules, and practices. It makes life so interesting, apart from anything else. It makes it fun. And Veronika is still doing it. This afternoon we met for a cup of coffee and started talking about the possibility of writing something together, actually arising out of that course. And within moments, the notes were piling up. There were notes all over the table. And we now have, or anyway, we will have, I hope, a clear idea of what we're going to do, how we're going to do it, and most of all, why we're going to do it, in about an hour and a half, I think, which was brilliant. So Professor Fikfak is brilliant. She's inspiring and inspired. I congratulate many people, as she did, but most of all, I congratulate UCL on its very perceptive appointment of someone who I'm sure is going to be a great star of the institution over many years. And of course, I congratulate Veronika on her chair, which I'm sure will be worn with great distinction, and I hope worn with great distinction for many years to come. So thank you, Veronika, for all you've done for me. Thank you for the lecture, and very best wishes for the future.
Thank you, David.
Hi, I'm Lisa Van Halle. I'm one of Veronika, Professor Fikfak's colleagues, and I'm not really sure why she asked me to do this, because I tend to weep through these occasions. So do forgive me if I start, because as soon as I say nice things, I start crying, and I have a lot of nice things written here, so be warned.
We can do it together.
It doesn't tend to go well with the British audience. Let me start with two off-the-cuff observations on Veronika's lecture, and I think they tie in really nicely to the 2 points I want to make about Veronika's excellence in research and her excellence as a research leader. In her lecture, you will have noticed that she tended to talk about, when she was talking about her work, it was almost always using the word our project, our findings. It really runs through who Veronika is as a researcher and the way that she approaches her work. The other thing that you might have noticed or might have caught, or I certainly did, was an off-the-cuff remark about my next ERC project. And I have to point out that this is, I believe, unprecedented in our department for someone to have had two ERC projects. They are incredibly prestigious for some of the students in the room who may not be familiar with them. Her work is absolutely at the cutting edge and valued. These are the hardest grants to get in Europe and are really, in the US, the equivalent is the Genius Grant, and she has now won 2 of them. So that was just a little thing that I noticed there, and maybe a little twig of jealousy having only had 1.
It's coming, Lisa.
But we can't ignore the fact that we're here together in a moment when we're, of course, facing immense challenges to a rules-based international order. 2 years ago, Amnesty International marked what they saw as a watershed moment for international law amid flagrant rule-breaking by governments and corporate actors, and that was before the current U.S. president came into power. The challenges to the rules-based system include populist and nationalist pressures, the ongoing digital revolution and its challenges, the distortion and corruption of news and information, and mass movements of migrants and refugees in the wake of multiple conflicts and climatic impacts, to name just a few. So I was intrigued and surprised to see hope being at the heart of your lecture, and was really looking forward to this evening. And what I've taken away is these 3 prongs of hope that I think you've put forward. International law as a label, a way of speaking truth to power, about accountability, it's about practices. I've also really taken away this idea that it's about the people, many who are in the room. I see a lot of the kind of finest minds in international law in this country sitting here today, and that really speaks a lot to both the quality of the work that you're doing, but the relationships that you have built. And you talked about the mobilization, and there's really something here about the kind of response to energy. And it's really important for us to hold on to this idea of hope, as Veronika has encouraged us to do, as researchers, to be able to continue with our work, as teachers, to think about the next generation and the importance of care in pedagogy, and as actors in the world, as human beings. David Lammy, the Foreign Secretary, noted a year ago that this is really a historic inflection point, and he was saying at that point the rules-based order on which Britain depends is collapsing. And he referred to it as a moment crying out for energetic diplomacy to match it, and I would suggest it is also a moment crying out for energetic scholarship. And I see what Veronika is doing as being on the cutting edge of that and not being afraid in this moment, but really looking in and leaning into that challenge. I want to talk about Veronika's excellence in research, and we've already heard a lot about that. At the core part of what she does is her interdisciplinarity. Veronika's focus is on international courts, and she consistently has to move between two positions. She has to see like a lawyer. She has to think and believe that law and courts matters, and that they can sit above the fray, and that they have a force. But she also has to see that courts are political institutions and that they are in the messy fray within a broader ecosystem of organizations and institutions and actors. And this dialectical thinking that runs throughout her work allows her to reveal practices and mechanisms and hidden actors that previous research has missed in trying to account for the relationship between states and international courts and individuals and the power of international law. Her research is also incredibly innovative. Her multi-method dexterity is another source of strength. For example, in her Human Rights Nudge project, her team analyzed 25,000 judgments of the European Court of Human Rights and undertook interviews across 10 countries to really reveal some surprising findings related to the types of remedies that are awarded and the high percentage of cases that are settled, partly to avoid precedent-setting judgments. And this really matters for the politics of these places and for who has access to justice, who gets justice. But of course, the skills that it takes to be an excellent researcher do not necessarily make one an excellent research leader. But Veronika has these skills in abundance as well. She cultivates research groups. She ensures that her research has impact, it translates, it matters in the world. For example, she's working now as an ad hoc judge for the European Court of Human Rights. And she contributes actively and energetically to building an enabling research environment within our department. In the field of international law, she's carving out real estate for the kinds of work that she does and is paving the way for others, for early career scholars to do so. And it's not easy to be that kind of pioneer within a discipline. It takes courage and it takes energy. She's doing similar things in our department. She's been a core part of setting up our law and courts cluster with Mikhail, thinking about how political scientists can engage with some of the topics that she's looking at and encouraging early career scholars who are working in similar fields. She's also working on reviving our human rights cluster with Kate and building cross-departmental collaborations. And this kind of institution building work isn't easy. UCL is a wonderful, brilliant, chaotic place, and doing that kind of bridge building really takes a lot of effort. In summary, I think what she does and what she's doing brilliantly, she's bringing her substantive academic knowledge of what it takes to navigate politics, to build collaborations, to kind of build institutions and craft solutions to thorny problems to the benefit of our department. And I think it's a better place because of it. So thank you very much to you, Veronika, as a researcher, as a teacher, and as a colleague. We're so lucky to have you.
Thank you, Lisa.